All right, good afternoon, everyone, and welcome to today's MSHA webinar series from Conn Maciel Carey's MSHA practice group. Today we'll be discussing MSHA's new and final Silica rule and legal challenges to that. My name's Nick Scala. Welcome back to those of you who we've had on prior webinar series, and welcome to those who are new to us. I am the chair of Conn Maciel Carey's National MSHA Workplace Safety Practice Group. Where we represent companies all over the country dealing with MSHA issues, from advice and counsel on compliance issues, rulemaking support, and litigation, like you'll hear about here today. And then also, the more traditional areas where we would think, which is challenging enforcement or managing investigations, whether those are serious accident investigations or agent investigations or discrimination investigations and complaints from employees. We represent companies in all aspects of dealing with MSHA and litigation for the Federal Mine Safety and Health Review Commission and the other elements there. We have a great discussion today laid out on the new Silica rule. We're going to really hit that from a number of different topics, going through a bit of history and a bit of what's to come, and some specifics on the monitoring side and the legal side that my colleagues are going to introduce themselves and run through as we get going. So I look forward to the discussion today, and I'll turn it over to Hema Steele to introduce herself.
Hi, good afternoon, everybody, or good morning, depending on where you are with us today. Like Nick said, I'm Hema Steele. I actually joined Conn Maciel Carey about a year ago exactly. And before that, I spent almost 12 years with the Department of Labor, Office of the Solicitor. So I was actually on the other side of the table representing OSHA, MSHA, and various other DOL agencies. Very familiar with OSHA, MSHA, and workplace health and safety. And you'll be hearing from me towards the end of today's presentation because I've probably spent the past 6 to 8 months really immersed in the world of the legal challenges with the new Silica rule. So like Nick said, really excited to speak with you all. I'm looking forward to your questions and comments. And with that, I will pass it on to Tony.
Thank you, Hema. Good afternoon, good morning, everybody. My name is Tony Castelletta. I am a senior counsel with Conn Maciel Carey. I've been with Conn Maciel for right around 3 years at this point. My area of practice is on the OSHA side. A little bit of background on myself is I was with Michigan OSHA for 18 years. I am by education, formal education, an industrial hygienist. I have a bachelor's and a master's degree in industrial hygiene, and that is primarily where I spent most of my career with Michigan OSHA, is doing industrial hygiene investigations. My first 3 years with my OSHA were done in general industry, doing manufacturing facilities, and my final 15 years were spent in the construction division doing on-site compliance investigations, air monitoring, and then doing some work with the asbestos program with Michigan OSHA. I was also a supervisor and manager with Michigan OSHA. So, like Hema had mentioned, I sat on OSHA's side for several years. So I have a pretty interesting and a good understanding of what OSHA is looking for and what the regulators are looking for. And then when I switch sides, that's why I was brought on, just so I can give that perspective, as well as my industrial hygiene background. So I've done a significant amount of sampling and review of sampling procedures and results with regards to crystalline silica. I'm here to assist today to kind of go over a little bit of the industrial hygiene side of things as far as the exposure monitoring and some of the nuances of the respiratory protection program. So I'm excited to be able to present to you guys today and answer any questions that you may have.
Great. Thanks, Tony and Hema, and we're glad you guys are on the good side now with us over here representing the employer and the management bar. So let's dive right into it, everyone. What is our topics today? We'll try to keep this as close to on time as we possibly can, be respectful of everyone there, and I think we'll be able to make that happen. But, quick review at the beginning of the status of MSHA's new rule. Where do we stand? When is it coming into effect? Look back at the current Silica regulation and enforcement. Specifically, we'll pay more attention to the metal non-metal side, where we've seen a lot of more aggressiveness from MSHA over the last few years. And then we'll dive into the new rule and, as we mentioned before, what the challenges are to the Silica rule and how that might play out in the final resolution of it. So let's look at the silica rule that we're going to be focusing on today and where it stands. So this was a rulemaking adventure that we went down with MSHA in 2023 and into 2024, the last half of 2023, when the proposed rule and then comment took place, and then in a pretty quick turnaround. MSHA published a final rule in April of 2024. The rule went into effect in June of 2024. And we have compliance deadlines coming up in just about a month and a day for coal in April 14th, 2025. And then metal non-metal has an additional year until April of 2026. That means until those dates hit for each industry sector, the rule is not enforceable. Inspectors can't require you to comply with provisions that are in this new rule. But nonetheless, the reason we want to talk about it is that there's a substantial infrastructure that we have to get in place in order to meet compliance when it rolls around, especially on the metal non-metal side, where a sampling plan and a regulation that requires this kind of robust sampling program, really has not existed previously. And that's why metal non-metal got an extra year beyond coal to comply. Coal has historically had more robust and prescriptive sampling requirements because much of it's in the underground operation. So, we'll dive into the new rule here shortly, but this is just a kind of a quick background about where we are now and how we got there with respect to the rulemaking process. This was a rule that had been talked about, for decades at MSHA. There was a lot of momentum back in 2016 when the OSHA rule came out that MSHA would adopt something very similar. The change of administration kind of set that off course, and then the Biden administration picked up again to push this one across the finish line. So with that, though, what is our current regulation looking like for silica? And, really want to look at it from the prospect of what is the current PEL or TLV, the way it's issued right now, and what are our testing requirements? Because as I mentioned, this is going to be a rule that really drives testing and is focused on testing, as we'll get into here in a little bit. Right now, the current PEL equivalent is a threshold limit value. It is incorporated as part of a document called the Threshold Limit Values for Chemical Substances in Workroom Air, adopted by the ACGIH, which is the American Conference of Governmental Industrial Hygienists, for 1973. So it is a 50-plus-year-old document right now, but essentially it says that approximately 100 micrograms per meter cubed is that exposure limit. For testing requirements, it's quite vague. It just says that surveys or samples shall be conducted as frequently as necessary to determine the adequacy of control measures, which is often something that gets metal non-metal operators. If you do collect a sample, or if MSHA collects a sample and it's over the TLV, you frequently get a citation accompanying that for failing to test as frequently as necessary. And one of the ways that we would get around that is you have regular testing records. Maybe you test annually or every 6 months, or you test when there's changes to your process. But if you can't prove that and you don't have those records to look back on, and maybe you just haven't had any overexposures for so long that you simply don't think it's required at this point, and we'll be able to get to a similar place possibly with the new rule, that a runaway sample can cause you to get kind of double enforcement here. And then also in the new, or in the current reg, they refer back to a respiratory protection program from 1969. Their new rule includes an updated respiratory protection program by reference, with Tony will dip into and kind of review what is part of that program here as well. As I mentioned before, we thought that there was going to be a rulemaking that pushed this across the finish line towards the end of the Obama administration. But when Trump 1 started, that got kind of pushed by the wayside. The Trump administration, the first time around, was very focused on analyzing the data and looking at what the percentage of overexposure was in the current reg, which was a very low amount, admittedly. but they didn't push forward the rulemaking at all at that point. It just got tabled. Then when the Biden administration took over, from the very, very beginning, it was well known that this was going to be a priority for them, and that certainly took the form in a couple ways. One is the rulemaking, and then two was rolling out a Silica enforcement initiative early on in the Biden administration after Assistant Secretary Williamson had been confirmed. And so that drove additional inspections, additional sampling at mines for silica exposure. With mines where there was kind of repeated silica exposure, we saw a lot of the framework that we have in the current rule kind of enforced in theory, meaning repeat sampling requirements, engineering control requirements in order to get out of it. MSHA took a pretty hard stance in that if you weren't making the progress that they thought you should be making or weren't addressing at the root of the issue, they would look very carefully and go as far to issue 104B orders, which are a failure to abate, which is it results in the withdrawal or the shutdown of that area or that processing equipment until you get the silica levels back under control and under the Pell. So this was a process that we saw play out quite a bit. In addition to that, part of the initiative was really what they called the miner's voice part, which MSHA spent a great deal of time talking with miners and working to educate them about their rights to make hazard complaints about conditions or exposure levels. Their ability to participate in the process, but we did see an uptick in the amount of employee complaints that were related to dust. And when there is an employee complaint related to dust, you are going to get an inspection that follows up. It may or may not include full shift sampling. Usually there is someone that comes out immediately. One of the strategies we saw was, beginning to see MSHA demand to see our sampling records. And if we didn't have recent sampling records, requiring that we get them in place and forcing the operator to kind of take the lead on that rather than them coming out and putting their samples in place and running with those. One instance that was particularly concerning is we had a client who there was a silica complaint or a dust complaint, and MSHA ended up writing a citation, but based off instantaneous read monitoring that the investigator collected on site. We were able to get that vacated because that is not proper. MSHA cannot issue a citation on an instant read snapshot of what they think a dusty condition might mean for an overall exposure. It has to be a full shift sample. So keep that in mind if you ever see an inspector walking around with one of those. You should not be receiving enforcement there. It might lead to a full shift sample, but they cannot issue it for an instantaneous measurement per their handbook on health inspections. In looking at what is the new regulation, we call it the MSHA Silica Rule or the respiratory crystalline silica rule, or RCS, as we'll kind of refer to it throughout because it's a mouthful, but the full name of this rule is Lowering Miners' Exposure to Respiratory Crystalline Silica and Improving Respiratory Protection. So an even more of a mouthful than just respiratory crystalline silica. It creates a new part of 30 CFR, the Code of Federal Regulations, where the standards and regulations that MSHA enforces reside. This will be a uniform mine health regulation subpart M or part 60. It will apply to both metal, non-metal, and coal industry. And you can see there, it's got definitions and then dives into the Pell that will be set and methods of compliance, all the way down to respiratory protection, medical surveillance requirements, record keeping, etc. And so we'll march through those and hit the highlights. There's a lot of information there that we could spend a couple hours running through. So we're going to hit the highlights for you today. And if you have additional questions that pop up, like I said, just please put those in the chat and we'll get to them when we can. So in terms of what the big changes, right, from the start is the exposure limit has been cut in half. As we said before, the TLV currently around 100 micrograms per meter cubed. This is going to be a Pell of 50 on a full shift exposure, which is an 8-hour time weighted average. And Tony's going to dive into what that specifically means later on. Additionally, they created an action level of 25 micrograms. So we immediately, like when we saw with OSHA, have a permissible exposure level that's 50% reduction and a 75% reduction in what is permissible in respects to an action level. And the action level will kick off some sampling requirements that we'll run into here in the next couple of slides. Another important element here is that MSHA is making this a rule where engineering controls are the aim, right? That is what they want to do. It's source control. They don't give us a lot of opportunity to do administrative controls. Obviously, that's part of the hierarchy, but their agenda is to force administrative or engineering controls that reduce it so that engineering controls are not nearly as important. Specifically, they prohibit the rotation of miners to help with exposure reduction. So we can't cycle people through a dusty job because that is going to reduce the exposure they might have. MSHA specifically prohibited that here. And Hema will talk about later how that's part of the challenges because that is, a very challenging and a useful tool that we're allowed in other situations to use rotation, but they're specifically prohibiting it here. In terms of, compliance, as I mentioned, engineering controls are going to be the priority. And that's what we've seen in practice, at least the last couple years, where, they were really trying to force exposure reduction through engineering controls. And that's how they wrote their citation so that therefore, they could go in and then write the failure to abate based on engineering controls. And I would expect that to continue in the metal non-metal industry, at least in the short term, until we get some of the leadership from the Trump administration in place, and they have an opportunity to get out their guidance and start getting out their strategies for enforcement. But, it places the burden on the operator to update equipment, to get new equipment, to, obviously maintain equipment in the condition that it does operate appropriately. But, MSHA, they often don't take a very global look at this. I mean, they don't seem to care that much. The logistics of maybe this affects our air permits, so now we have to update our permitting and the process that's included there. They want to see action very quickly, and they almost always go to the inclusion of ventilation systems that can take the dust away from where it's working. And obviously that it's a great idea, and we all want to that all sounds well and good, but those are things that really can affect our other permits that we have in place. So source control, you have to sometimes look at how can we eliminate the dust rather than removing the dust. So that's something to concern or be aware of as you move forward. And just if you are dealing with MSHA in this, you have to be pretty transparent with them about what it's going to take to do what they think you have to do. And if there are alternatives that might allow us not to have to change our air permits, then we need to talk through that with them to avoid the sense that they feel like we're not taking any action. But otherwise, their view here is going to be administrative controls are a supplement. But what they're going to be pushing on us and have been pushing on us is that engineering control. In terms of monitoring and testing, this is at the beginning, a very testing heavy rule. And so what does that look like? MSHA is looking at this from a couple of different areas. They call it a qualitative and a quantitative review, meaning they want to see us be doing sampling and proving what our levels are for specific roles, and then later doing evaluations of our process and getting to the point that we are documenting what changes have been made, if there's any, do those affect our exposure, and so on. But the initial request is that everyone is going to have to be collecting samples for their positions which have a reasonable expectation to be exposed to respiratory crystalline silica. MSHA's mind is that this includes all miners in processing and extraction. So that's going to cast a pretty wide net on us immediately. You can use representative sampling, but it's pretty limited in terms of representative sampling. You can't grab a representative sample of a haul truck driver, from one shift and then say that covers everybody on multiple shifts. Their expectation is that representative can only mean miners performing the same task in the same area on the same shift. So if you have multiple people collecting or performing the same task across shifts, you're still going to have to collect a sample per shift. That is not necessarily how we deal with representative sampling in other contexts, but that is specifically how this rule is written. So something very important to keep in mind as you're starting to lay out your sampling plan. That's how it is looking.
Hey, Nick, if you don't mind, let me jump in here real quick on the representative sampling and then the
Sure.
use of data from other sampling operations. So, we see a lot of this in the OSHA side, and I saw a lot of this in my practice during my industrial hygiene times, as well as being an attorney and representing other clients. We see it with lead, we see it with hexavalent chromium, cadmium, metals, and silica as well too. Is that when you're going to use representative sampling and use it to compare one shift to another, you definitely need to make sure you're comparing apples to apples. And it's documentation heavy. So whoever's going to be setting up and doing your air monitoring, and you plan on using it for another shift or another work operation, make sure that you're taking very accurate records. So in the event that there are questions as to whether or not this is representative, you can show and say, like, look, this is what the employees were doing. This is the work operation. This is the amount of whatever. And you can show that, this is indeed apples to apples. And I ended up seeing a lot of citations, both writing and then also representing employers and trying to contest these citations as to, how can we show that this is representative? It's pretty easy to poke holes in these sampling results. So again, make sure, and I'll talk a little bit about this here shortly, is that make sure that you're taking good records and make sure that you're utilizing a good industrial hygiene firm whenever you're doing the samples and setting up the sampling procedures and process. Sorry, Nick, I didn't mean to derail you there.
No. That's all good information, because that is something that we're going to have to rely on, right? We need to set up representative sampling, or else we're going to be sampling everybody, which is not feasible. For the sampling that we take here, the expectation is that this is going to begin before we get to that, mark in April of 25 or April of 26, depending on your industry you're working in. But the idea is that you want to collect two samples that are below the action level of 25 micrograms. And if you can collect those two samples, then you can discontinue sampling until there's a change in your process, or at least you evaluate something that could be a change. Previously, MSHA in the proposed rule was going to allow individuals to rely on, if you collected one sample that came back below the action level, the second could be, relied upon for other objective data, or another sample taken within the prior 3 months, or sampling data from the last 12 months from the operator or MSHA. They changed that in the final rule that you have to collect another sample, which is a frustrating development. But that the expectation now is that this is two samples in order to get out of continuing that sampling if they're below the action level. If you're above the action level, but below the PEL, you're going to have to continue sampling every 3 months, or at least within that every 3 months. If you are above the PEL, you're going to have to do what is termed as corrective action sampling. So if you go above the PEL, above that 50, you're going to have to, immediately implement some corrective actions, things to do to get that PEL or that exposure level below the PEL and the action level. And then as soon as you put those corrective actions in place, you got to collect another sample. And based off that sample, you'll be able to possibly remove people from respirators in the area, or you'll have to, if you're above the PEL still, put into place additional corrective actions, and be mindful that we need to be intentional in documenting what we're doing, so that if MSHA does ask, we can prove that we are actually taking corrective action and pushing those forward, and we're not kind of sitting on our laurels, just cleaning the area up and resampling after that. A concerning provision that was added to the final rule is that if you collect a sample over the Pell, the requirement is now that you immediately report it to MSHA. They say it's because they want to stay on top of exposures, and that it won't always result in enforcement. But I think, those of us who have worked in the mining industry long enough and dealt with MSHA frequently enough, we expect that if you're submitting evidence of non-compliance to the agency, you're likely going to be getting a citation as well. So that is kind of an added wrinkle and one that's going to pose a challenge for us as we move forward, and has been giving a lot of people heartburn since it was included in the final rule. In terms of the periodic evaluation, this is going to have to happen every 6 months. And after you begin sampling, and whenever there's a change in process, installation of new maintenance of engineering controls, installation of new equipment, or even changes in geological conditions, which I think is a pretty broad topic for MSHA to include here. But the idea is that you go through your process, you mark anything that's changed, and you make a record of that. You have to post this record in a public place at the mine, whether electronic or physical, for 31 days after it's made. You have to then determine if there is changes that are going to increase your exposure. You have to do post-evaluation sampling. Now, I think logically and reasonably, the way this is written is what I just said, that if there are changes that would result in additional exposure, you would have to do this post-evaluation sampling. But those of us that are cynics read this section 60.12D as a little more unclear than that, right? Because it says the mine operator determines as a result of the periodic evaluation that miners may be exposed to RCS at or above the action level. The mine operator shall perform sampling to assess. And the reason I say that is definitely not as clear as we want it to be, is it doesn't say if there's a change that would result in increased exposure. And 25 micrograms is an incredibly small amount. If you have any presence of silica at your operation and in your product, or in the material that you're going through or processing to get to your product, it's very likely that people could be exposed above the action level. I mean, that's one pile of dust that puffs up, or someone, is working on maintenance and, pulls a bolt out, and that bolt has, results in some dust falling on the pump or in their face. It's a very low amount. And I think probably long term, this is a provision that could be used by MSHA to require essentially semi-annual sampling for operations that have silica present. Because once you go through that initial sampling, you get those 2 samples below the action level. There's no other requirement that you continue to sample those on a regular basis unless the periodic evaluation says you should sample again. And so, I think long term, this is possibly a provision that could be interpreted by the agency and enforces the agency to require regular sampling after we get through this first wave of the initial samples for operations that have silica present. So, food for thought. Again, MSHA, of course, said during the rulemaking process, that's not the way it's supposed to work. It's going to be if there's increases, but that's not the way it's written. And they, intentionally did not revise it during the rulemaking process, because I know there were comments, some of which, we submitted on behalf of clients or help clients prepare specific to that point. But I think, Tony, you're going to jump in here and talk about some additional details on the exposure monitoring front.
Yeah. So yeah, thanks, Nick. And yeah, to your point, Nick, 25 micrograms is not very much. And it's not going to be difficult for an employer, especially in the mining industry, to exceed that in a typical workday. And it's we see a lot of this in the construction side of it. It's the exposure levels are similar as to federal OSHA. And what I see in my practice, with construction and employees that are doing tuck pointing operations, grinding on mortar or mixing concrete or concrete cutting for that matter, it doesn't take much for these guys to get overexposed. The good thing is that it's based on a time-weighted average. It's not an instantaneous exposure. It's averaged over an 8-hour time-weighted average. So while you may have an elevated exposure for one short period throughout the day, if your exposure for the remainder of the work shift is relatively low or non-existent, that one exposure, that elevated exposure, probably will bring your average below the action level. So again, a few things to think about. But before I get into that a little bit further, let me just kind of go a little bit about there's the basics of crystalline silica sampling. It's a very easy and very simple process for the sampling. But that being said, there is an art to it. Section 6012E does go over some of the sampling requirements. There's not a whole lot of detail in this section, but it does make some references to various sampling methods such as MSHA P2, NIOSH 7500, and the OSHA ID 142 as far as setting up the sampling protocol, and the analysis. So again, everybody's kind of on the same page here as far as how the analysis and the setting up the samples go. So again, any industrial hygiene firm or whomever it is that's going to be doing your sampling, it's a pretty simple setup. You can see here the sampling shall be performed for the duration of a miner's regular shift and during typical mining activities. Again, this is because they want to make sure that they're getting a representative sample for that employee. And what is interesting, and you'll see this down in the next paragraph here, is they're talking about 8-hour time weighted average, but it appears that most employees that are working in the mining industry are working beyond the 8 hours, sometimes 12 hours. The permissible exposure limit it is based on an 8-hour time weighted average. So you would take that 12-hour time weighted average and you would use those results to compare it to the 8-hour time weighted PEL that's established. There's a question here that talks about instantaneous read monitoring as well as continuous monitoring. Continuous monitors are if you're referring to like an area monitor, that's different than a personal monitoring. So when you see here in the section that talks about the 6012E, talks about personal breathing zone air samples. So those are air samples. When they're setting up the air sampling, the industrial hygiene monitoring, it needs to be put in the employee's breathing zone. And that's just a 10-inch radius around the nose and mouth. So those of you who are unfamiliar or haven't seen any type of industrial hygiene sampling before, typically what happens is whoever's doing the sampling is going to apply the sampling media. Think of it like on their collar or just on the top part of their shirt or their coveralls or whatever it may be. That way it's within 10 inches of their nose and their mouth. That way you can get an accurate representation of the sampling of what these employees are breathing in. And the sampling media is a little bit different too. What they typically utilize, it's what's called a cyclone sampler. And what this does is this filters out the very, very small particles that are going to be penetrating deep into the lungs. And that's really the problem with crystalline silica and the respirable fraction of it. The respirable fraction is anything less than 10 microns inside, which is right around the width of a human hair. And these are the particulates that when you breathe it in, it does not get trapped in your upper respiratory, it doesn't get trapped in your throat or in your upper respiratory tract. These particles can penetrate deep into the lungs and get into the blood oxygen exchange area, the alveolar region of the lungs, and that's where you start to see the development of the lung disease silicosis. And we see it similar. It's similar to asbestosis as well, where the fibers could get in there and cause damage deep into the lungs. So the sampling media is very specific to this type of work operation, to this type of particulate. And again, whoever you're using to do your air sampling for these processes, make sure that they're familiar with this. The next thing, permissible exposure limits. We talked a little bit about the time weighted average. So again, 50 micrograms per cubic meter for a full shift exposure is not much. Again, that's calculated over it's calculated over their full exposure, their full day. So again, while you may have an elevated exposure for maybe 1 or 2 hours, if the exposure is very, very low for the remainder of their shift, that can likely bring down the exposure limits, the time weighted average to below the action level. But again, it's just going to depend on the work operations. But what I did find interesting, and what Nick was just mentioning earlier, is that there's a hierarchy of controls in industrial hygiene, which is in engineering controls, administrative controls, and then personal protective equipment. Worker rotation is an accepted administrative control, and it's interesting to see that this specific rule is not permitting that. Yeah, I was kind of surprised to hear that, but that is an effective way of controlling employee exposures. So again, all exposures are then compared against the established permissible exposure limit of 50 micrograms, as well as 25 micrograms for the action level. And again, when we're dealing with this, employees that are working beyond their shift, it does generate a potential for, are we really looking at a representative exposure? How does this apply to an 8-hour shift? It's not really good industrial hygiene, if you ask me. But this is the rule that we have, and this is what we have to comply with. So it's not always apples to apples. So 12-hour shift exposure is not always going to be representative of what an 8-hour exposure is. But that's what we have. If there's a low exposure, that's it doesn't really make much of a difference. But if you're looking at some elevated exposures, especially those within the between the action level and the PEL, you're using the 12-hour data and comparing it to an 8-hour PEL. It is a little problematic.
One question was related to, what has to, if you are doing continuous monitoring or an instantaneous monitor, could that result in an overexposure? And you need to have a full shift, right? This is a full shift sample. And so what Tony just went through is, the process of collecting that with a cyclone and a monitor that you then average that out over the shift. So you should not be receiving enforcement based off an instantaneous read.
No, instantaneous read is really that's the screen. We would just use as a screening sample to say, okay, the workers in this area have an elevated exposure. We're seeing high concentrations of crystalline silica in here. Maybe we need to adjust the ventilation that's going on in here, or maybe
we need to take a full shift sample and find out, how that's being affected.
Exactly. Yeah. So, okay, so next slide we have here is for record keeping. So this is, federal OSHA has similar record keeping requirements for their expanded standards with regards to specific chemical compounds like crystalline silica. And this just discusses, how long you need to maintain your records. So your evaluation records, sampling records, corrective action records, all of these need to be maintained for at least 5 years, either from the sample date or from the date of the corrective action. The written determination records for the medical evaluations from the PLICP is duration of that employee's employment plus 6 months. So those are a little bit different than what we would see in federal OSHA. And the reason I keep bringing up federal OSHA and the difference between these two is we just want to caution employers to say, sometimes we have employers that are doing both construction work and mining work, or they have a manufacturing facility or whatever it may be. It's not an exact change between those. So it's the respiratory protection standard, and we'll talk about that here. You can't just take the one that you have for OSHA and bring that over here. And the same thing goes for record keeping. The record keeping requirements are a little bit different for the mining industry versus federal OSHA. Federal OSHA requires records to be maintained for 30 years versus just 5 years or 6 or the duration of the employee's employment. So a little bit different, but just something to kind of keep in mind, just a little food for thought. So corrective action and PPE.
A big part of this is, as we talked about, corrective actions, because this is what the rule is really intended to do. I mean, it's intended to reduce exposure, yes, but how does MSHA want you to do that? It wants to force modification or force technology generation to reduce that. So what happens though if you get results over that PEL that we've been talking about, that 50 micrograms per meter cubed over that 8-hour time weighted average? Well, you have to implement corrective actions. You also have to ensure that by the next shift, you have the affected miners wearing respirators properly. And Tony's going to talk about, here probably on the next slide, why that's a important provision, because that is going to mandate that we have respiratory protection programs already in place, have that respirators already on site. N95s are not going to be compliant. You're going to have at least Series 100 or greater protective equivalency equipment for this. So, that is something that we definitely have to keep in mind, and that the miners are going to have to be in these respirators until we collect a sample after corrective actions that is at or below the PEL. Even if it's not below the action level, if we get below the PEL, we can stop respirator use as a requirement. And then obviously we'll have to get it below the action level, lest we just continue to collect a quarterly sample, essentially. Once the corrective action's been taken, as we talked about, you have to collect that second sample and then take additional samples and new corrective actions until we are below that PEL. And then, the other part of this is the respiratory protection program. Respirators are not a compliance method here. You can't use them to do that, so you have to have, they're only allowed to be used while you're, maybe doing a specific task that can't be controlled, changing out bag houses comes to mind, or while you're implementing the engineering controls to get them back below the PEL. So, be mindful of that. Technically, MSHA's mindset, at least in the preamble of this rule, is that if you're wearing a respirator, you're likely not in compliance because someone is going to be exposed above the level. If you have miners who can't wear respirators because of medical reasons, like Tony's going to talk about here in a moment, you have to get them transferred to another area until you no longer have to wear a respirator to work where they originally did. And this is somewhat similar to Part 90. Metal on Metal probably isn't as familiar with Part 90, but in Part 90 in the coal industry, says that if someone's been affected by black lung or something along those lines, you have to move them to another area where they won't have to be in the same conditions, and they stay in that area at the same rate of pay, the same benefits, the same level of seniority, even if it's a different role, because of that. And that's what MSHA is looking at here, right? You have to move the person that can't wear a respirator until you have the area back to a state where you don't need one, and they have to receive the same comp, same regular rate of pay. You're going to have to be careful with, moving to, maybe a night shift versus a day shift. It's a little bit of a lift to coordinate this logistically, but something that has to be kept in mind. And Tony's going to talk about what that respiratory protection looks like right now. One person asked, if it takes 2 to 3 weeks to get results back, or is it expected to wear respirators until the new results are back? Yes, that is the anticipation. Until you can verify the samples are down below the PEL, you have to keep them in respirators. And I know some of the labs have, for a much higher fee, you can expedite those results. So some get them back to you within 24 hours if you overnight samples to them. But those are things that companies are going to need to look into and evaluate. Is if we've implemented controls, can we get a expedited result? If so, how quickly can you do that? And there's a big question about the bandwidth, right? Those 2 to 3 weeks might be much longer if all the labs in the country, of which there aren't that many, are suddenly bogged down with a surplus of samples to analyze. So it is a concern. It is a question that we have. And to answer that one, yes, they would have to wear the respirators until you got verification of the results. But Tony, you want to jump into respiratory protection program?
Sure. Yeah, and I'm gonna kind of go through this pretty quick because I want to make sure Hema has an opportunity to kind of go over her slides as well too. But just quickly though, the respiratory protection requirement under this standard requires compliance with the ASTM F3387-19 requirements. And as I mentioned earlier, this is in reviewing this specific respiratory protection program, these guidelines that that employers are required to follow. It is a little bit different than what you would see with a regular Fed OSHA respiratory protection program. So again, make sure that we want to make sure that you understand that and that you're not just taking your Fed OSHA, your OSHA one. If you have a construction project or if you have a manufacturing facility and say, okay, we're just going to use this for our mining operations, you can't necessarily do that. There are some similarities there, but this is a little bit nuanced. So, what are the basic requirements for this, the standard practice for respiratory protection, this part of the standard? First off, the selection of respirators, they all need to be NIOSH approved. There really isn't any difference between this requirement and then what federal OSHA is. Nick had mentioned a little bit earlier about the difference between, you can no longer use an N95 respirators, you need to use the 100 classifications. And the difference between those two is fairly significant. Not a lot of people understand this, but an N95 respirator, those respirators are designed to filter out 95% of the airborne particulates versus a N100 or P100. Those are designed for a 99.97%. So definitely much more effective in filtering. You also need to establish a program administrator for the respiratory protection program, and this is somebody that needs to be named in the program itself. So this is somebody that, they're responsible and have the authority for the respiratory protection program. It has to be a single person, or it needs to be assigned to a single person. And this person, whoever the program administrator is, everybody that's working on the site or that's going to be part of this specific program needs to be aware of who that program administrator is. They also are responsible for keeping updated on any issues or current events associated with respiratory protection, and they're required to annually audit the program. You'll need to develop and implement a written respiratory protection standard operating procedure. And one of the interesting things that would be required for this program is the hazard assessment. So this hazard assessment, which will probably likely be something that you could probably use from site to site, but it does sound like it needs to be relatively tailored to, specifically tailored to that site. So while mining operations are probably not going to differ too much from area to area to area, you could probably use the same program, but it does need to be tailored to that specific site location. So you need to identify hazards, including potential respiratory hazards such as oxygen deficiency or other airborne contaminants. This will all need to be included in the program, and possible conditions that could be potential eye and skin hazards. Depending where you're working, there could be humidity issues or temperature extremes and other environmental issues that could exist that could affect the use of the respirator. So all of this needs to be done and included in the respiratory protection program. The program also needs to discuss respiratory selection, medical surveillance, specific employee training, fit testing, maintenance and inspection and storage of respirators, change schedules for filters, reevaluating hazards if they come up, and evaluation training and auditing. Provide training to each employee that is assigned to wear a respirator. This needs to be done prior to the employee being assigned a respirator, that they're going to be doing work with a respirator, and it has to be done annually. Establishing and coordinating medical evaluations for respirator use. This is something that, if you know that employees are going to be required to wear a respirator, you want to make sure that you kind of get ahead of this a little bit, because, you don't want to get into a situation where, like, oh goodness, we need to get this person into a respirator and medically evaluated. There may not be a Concentra around the corner. You may need something that you need to schedule. So something to just kind of keep aware of. Ensure employees are properly fit tested before wearing a respirator. That's a fairly simple task. Anybody can really do the fit testing. The fit testing is the medical evaluation that's a little bit problematic. But as far as the fit testing, there are established procedures that are outlined as to how to fit test an employee, both qualitative and quantitative operations. And then finally, ensure that respirators are properly stored, inspected, and maintained. So whoever's the respirator coordinator is going to make sure that that's being properly done. It needs to be outlined in your program. So again, it's a pretty standard program. There's not a whole lot that is different than federal OSHA, but there are some quirks and some nuances in there, specifically, talking about the program administrator, the hazard assessment, and things like that. And so just something to be aware of. And again, if you have any questions on that, please don't hesitate to reach out to us.
The medical surveillance is new to the metal non-metal industry. Coal has had to, go through medical surveillance for a while, but what this rule also includes is medical requirement for metal non-metal to make medical examinations available to current employees. We have to open that up for the first 12 months after the compliance date, and then make it available every 5 years after that, at least, so that current miners can opt in if they decide to do so. It's not required, but we have to make it available to them. New miners that are new to the industry, meaning they have never worked at another mine, whether it's a coal or metal mine, they are brand new to the mining industry, are required to go through this medical surveillance and examination process within 60 days of employment. And then you have to mandatory follow-up within 3 years. And then after that, it becomes a voluntary process again for them if they want to continue to it. I mean, essentially what, MSHA is looking for here, though, is in 20, 30 years or so, they're going to have a baseline for everyone in the industry, and really going to start collecting that data if there is decreased lung function due to silica exposure, or at least if that's what they believe it could be. A lot of things can affect decreased lung function as it is here. There is a requirement that you have to submit these to NIOSH, even though the system that NIOSH is going to house them in isn't created yet. But when it does create, the expectations, you're going to supply this to the government so that they can maintain this database as you move forward. There's a lot more to this medical exam piece. It's probably going to be one of the infrastructure-wise, the heaviest lifts for metal non-metal to get involved. There's not a ton of places that can do that, chest x-rays and all that. But for the sake of time, we're going to turn it over to Hema, who's going to run through the legal challenges. I think that's an important element here as we move forward. So if you can stick with us for a little bit over that hour, I appreciate it. If not, we're going to get that recording out to you, but we're going to continue the discussion and give it its due course here while Hema runs us through the legal challenges.
Thanks, Nick. Yeah, like you said, hopefully you all can stick around for about another 5 to 7 minutes, because while Tony and Nick really gave you so many great details and pieces of information about this rule, I'm going to talk about all the attempts out there to get id of it. So real quickly, for those of you who are unaware, federal rules and regulations do permit entities to challenge a new rule that's issued by an executive agency. And very quickly here, typically that's 60 days after the rule comes out, there's that window to file a challenge. And when you do that, at least in this situation with an MSHA rule, that gets filed directly with a circuit court of appeals. And what the court is looking for, sort of the barometer or the yardstick, if you will, I've got these listed: the arbitrary, capricious, abuse of discretion, so on. Really what that means is the court is looking to see, did the agency go too far? Did MSHA go too far, or did MSHA have sufficient justification for issuing the rule? So with respect to this Silica rule, we ended up with two entities or two groups who filed within that 60-day period. First, we had the Sorptive Minerals Institute, which, in full disclosure, Conn Maciel Carey is representing SMI in this challenge. That's a trade association for the producers and marketers of products that contain absorbent mineral clay. On the other hand, you can see we have an industry coalition of national and state associations. You see them listed there. Unlike SMI, which is challenging the rule on a very sort of narrow ground and is trying to be exempted based on its industry, the industry coalition challenge is trying to get rid of the rule in its entirety. So I'm going to walk you through real quickly what those look like and why those challenges are there. So SMI's challenge springs from the fact that when OSHA did its rulemaking on silica back in 2016, OSHA explicitly exempted the absorptive minerals or the absorptive clay industry. The reason for that was because OSHA determined that there was not enough evidence to show a significant risk that the silica in this clay pose a significant risk to material impairment. And that idea of significant risk, that's really critical to SMI's challenge. The years ago, back in 1986, the United States Supreme Court, in what's come to be known as the benzene decision, said, hey, OSHA does not have authority or statutory authority to regulate anything and everything it wants, and that it's unreasonable to think that Congress expected OSHA to regulate anything regardless of the size of the risk. So Supreme Court said, nope, OSHA, you have to be able to show that there's a significant risk of material impairment before you promulgate a health standard. So we fast forward to the silica rule, and MSHA says, well, we're not abiding by that significant risk requirement. That's an OSHA requirement that the Supreme Court placed on OSHA. There is no similar requirement for MSHA. And despite the fact that historically, either explicitly or implicitly, MSHA has abided by this significant risk threshold. They refer to it in various places throughout prior rulemakings and in legal challenges. But in 2021, there was an 11th Circuit case that came out and said, no, significant risk only applied to OSHA. MSHA, you don't have to do that. And so SMI's challenge is really saying to the 8th Circuit, hey, this significant risk threshold should apply to MSHA in the same way it does to OSHA. And why is that important? It's important because if there are no parameters or no sort of guardrails on how far MSHA can go or what they can regulate, you essentially end up in a situation where we're saying that MSHA has no guardrails. It's exactly that. They can kind of regulate whatever they want without any sort of guardrails or requirements. And one of the arguments that SMI is making is that that's a result we don't want to get to because there's what's called a constitutional concern of non-delegation doctrine. Because if you don't give MSHA guardrails, you're essentially giving them the authority to make law instead of interpreting the law and providing ways to interpret a law. And if you're giving them the ability to make laws, you're essentially turning them into a legislative, the part of the legislative branch, which they are not. So that's kind of SMI's challenge. The basis for SMI's challenge is, hey, like we're not necessarily saying there's anything wrong with the rule. It's just that MSHA should have more guardrails. And if they had used those guardrails, they would have come to the same outcome or the same conclusion that OSHA did, which is the absorptive mineral industry should have been exempted. So as a result, SMI is just asking that the court either partially vacate the rule as it relates to the absorptive minerals industry, or to remand it, which means send it back to to MSHA and say that MSHA, hey, you need to go back and reanalyze this rule under the following rubric. The Industry Coalition Challenge, as I mentioned earlier, they are actually looking to vacate the rule in its entirety. And Tony and Nick kind of touched on this during their presentation, which is that these coalitions are saying, hey, these requirements that MSHA has put forth either are not based in any kind of sound logic or reasoning or scientific evidence, or are infeasible, and you're just asking far too much of mine operators without sufficient evidence or support for these requirements. And you can see here, got some listings here about whether it was arbitrary for MSHA to require all this level of sampling, this level of surveillance, as was discussed earlier, issues related to rotations, things like that. So where are we right now? Just to give you a sense of where this litigation is right now. The SMI had filed its challenge in the 8th Circuit, while those other industry coalitions had filed in the Fifth Circuit for various reasons. Everything got shifted over and consolidated into the Eighth Circuit, which is based in St. Louis. So the Eighth Circuit is the one that will be hearing this challenge. Briefs have been filed. There's another round of briefing that SMI and the industry coalition will be doing just in a couple of weeks here. In addition, for those of you who are not familiar with the concept of amicus curiae, those are essentially called friends of the court. Those are outsiders, outside entities who are not parties to the litigation, who request permission, and if granted, submit briefs to provide sort of background and additional detail to help the court understand some of the issues at play. So you can see here, we kind of have an even weight, or excuse me, not even number of entities that have submitted briefs both in support of the challengers, meaning the petitioners, as well as supporting MSHA's rulemaking. So where are we headed? We have learned that the Eighth Circuit intends to hear oral arguments on this matter, but we don't know when that will be. Likely summer at the earliest. And if that's what we're looking at for the oral arguments, we would not be looking at a decision on this case until the later part of this year at the absolute earliest. Now, it's important to keep that in mind because, as Nick mentioned, we've got enforcement coming up in 2026 for metal, non-metal. So real quickly, ways that what the possible outcomes are. We could have a settlement. What that looks like, who knows? There's a lot of issues at play here, especially with the new administration. There's also the possibility of an administrative or judicial stay. That means either MSHA agrees to stay the enforcement of the rule, or somebody petitions the court and says, hey, court, will you force MSHA to stay and essentially not enforce the rule for a particular period of time? Or this goes all the way through to a decision on the merits. We have oral argument, and then we get an opinion where we get the Eighth Circuit saying one of these things. Either they say, yep, the rule is good to go, we see no problem with it, or they could have a vacatur, which means essentially vacating the rule in its entirety or in part. Or like I mentioned, they could remand and send it back to MSHA saying, hey, MSHA, you need to redo or relook at certain aspects of the rule. A couple of things that to be mindful of that have come up in the past with respect to ways that maybe the rule might go away or might change. There's a lot of limits on what MSHA can do at this point. There's mention here in this slide about the Congressional Review Act. That's a law that essentially says that when a new Congress is seated, they have the right to go back up to 90 days and revisit any rules issued by agencies. And that really kind of prevents an outgoing administration from doing 11th hour rulemaking. But unfortunately, this Silica rule went into effect, or excuse me, we had the final rule more than that 90-day period. So that's kind of out of the reach of this session of Congress. And similarly, to the extent MSHA of its own accord under this administration chooses to ease back or change aspects of the rule, they're also limited by a provision in the Mine Act known as the no less protection clause. And it explicitly says that once a rule is promulgated, the secretary cannot change it so as to reduce protections for miners. So that really kind of puts MSHA in a corner. It's hard to say where this could ultimately go. So with that, one other thing to note is, of course, like I mentioned, we're under this new Trump administration. A lot of speculation about what this is going to look like. We do have the new labor secretary who was just confirmed very recently. So hopefully we'll see some kind of, potentially some sort of movement on this rule or some kind of guidance from the agency. And similarly, a lot of people I think would think that under the Trump administration that maybe there'd be a very quick changing of the rules. But again, going back to this no less protection clause, this exact issue went to court under the Trump administration, and they lost. And the court said, nope, under that no less protection clause, the secretary does not have the authority to amend the rule in a way to reduce protections for workers. So with that, sorry that was very, very quick. With that, I will pass it on to Nick for some closing words.
Yeah, thank you, Ham. I appreciate that. And I mean, I think she hit on an important point at the end there. I mean, there's obviously, I think, some hope in the industry that, this new administration is just somehow going to change this rule, and they're somewhat hamstrung in their ability to do so. And as Hema mentioned there, I mean, this enforcement of the provision of the Mine Act that, we call the no less protection clause, that says that they cannot promulgate any rule that is less protective than an existing rule, which this is an existing rule because it's final. I mean, we saw that the case that she's referring to is the workplace exam case, from the first, that was one that got kind of kicked through the door and finalized at the very end of the Obama administration. The Trump administration didn't put it into effect and really enforce it, and made some changes about a year later. And the unions in that case sued MSHA, saying that it violated this no less protection clause. And the DC Circuit agreed that MSHA, really in that case failed to justify that the new rule, the revisions to the Obama era rule, didn't reduce the protective nature of it. And so, that roadmap has been already drawn out. And so, if we see unilateral changes to this rule, I mean, we should expect that the unions will, immediately be back in the DC Circuit when they've already succeeded trying to get a similar result. So a good bit of unknown, what is the rule going to look like? How's it going to be enforced? How aggressively is it going to be enforced? Those are areas where, we're going to be seeing things kind of play out here in the near future. And as we get political leadership at MSHA, we should have a better idea about that, what that looks like. We now have a confirmed Secretary of Labor. As of just last week, we are going to likely see, at least I hope, in the next few months, a confirmed Assistant Secretary for MSHA, Wayne Palmer, who was in the administration during the Trump first administration, and then since then has worked for the Essential Minerals Association, is the nominee right now to lead MSHA. He is someone who's obviously dealt with the Silica regulation while he was there, and also in his capacity in the association world until his nomination. So, it is a front of mind issue in the mine safety and health world. We're going to continue to see kind of the evolution of it. But right now, it is in effect, and coal is going to have to comply in the next month, and metal non-metal is going to have in 13 months, but you're going to have to start preparing for it and laying out your infrastructure, because it's a big enough rule that you can't wait till the last minute, especially if you're going to have to do some initial sampling, and that results in the need to install engineering controls. Ideally you want to go through that legwork before the rule becomes in effect, because that will give you a little bit of freedom to not have to submit any overexposures directly to MSHA immediately and self-report. Something that we're working with clients right now and consultants to help them kind of evaluate where they stand and maybe where the improvements have to be made, so that when the rule does go to an effect, we're in a very good place and we're already in compliance. So if that's something that you or your organization are interested in, I urge you to reach out to us, and we can help walk through what that looks like, about how we work with you all to kind of get ahead of this under the regulation of the current rule, where we have maybe a little more freedom to, navigate and go through a troubleshooting process before it really gets prescriptive. With that, we appreciate you guys, those of you who hung in here with us for the entirety of the webinar today. Please continue to join us. We hope you found it helpful, and we'll have another one coming up next month, talking about whistleblowers, statutes, and how we handle and respond to those with the Mine Act, and some of the unique elements that are included there. We'll also keep you guys updated in writing about what's happening at MSHA on the MSHA Defense Report blog, as well as, things happening on the employment law side, and OSHA, and even our Cal OSHA specific practice, which is a very busy area, and one that we expect to see continue to be busy during the next 4 years, regardless if we see a contraction on the federal level. And then, as always, you guys can reach out to us directly too. The chat's not the end of the game. Here's all of our contact information, all of our emails. Feel free to reach out to me, Hema, or Tony, or all of us, and we'll definitely get you an answer on any other part of this panel discussion today, on whether it's the compliance side, what the rule requires, the scope of the rule, which I know is some of the questions that I've seen coming in that we'll respond to you directly on, or getting in down to the specifics of how do we build out a plan, or if you need help with that plan on respiratory protection or sampling, obviously Tony is a great resource for us there. So thank you very much, and appreciate everyone's participation today. Have a great day and a great weekend.